Good morning, ladies and gentlemen. Welcome to Bexar County Court at Law number 6 and the Bexar County Veterans Treatment Court. This is our Friday pretrial hearing docket. This is Judge Wayne Christian. Representing the state, we have Ms. Alexis O'Connor and Mr. Guillermo Flores. The cases I have set for today are motions to revoke probation, the state of Texas versus Sidney Chavez, cause 649-066, represented by Mr. Raimundo Aleman. Cause number 652390, State of Texas versus Alexandra Arzola, represented by Judge Monica Guerrero. We have two non-disclosures pending. Shane Paleka, 355713, and Jason Berry, 804299. We have motions to dismiss for lack of speedy trial. State of Texas versus Alexis Stevens, 653674, represented by Mr. Mark Lassiter. Let's see, 642487, State of Texas versus Michael Reff, represented by Mr. Brian O'Donnell. And cause 633445, State of Texas versus Patrick Salazar, represented by Mr. Brian O'Donnell also. And we have a motion to quash on State of Texas versus Charles Alex Danner, cause 650297, represented by Mr. Michael Goins. We're going to start out of order, so to speak, with Ms. Stevens. Motion to dismiss for lack of speedy trial, represented by Mr. Mark Lassiter of Dallas, who is with us today. And Mr. Lassiter, I apologize. I understand you've had a death in the family, and that's going to try and get you out of here as soon as we can.
Yes, Judge. I apologize for my appearance. Normally I'd be in a suit.
We're just happy to see you.
I've been driving for 18 hours straight now.
All right. Well, no problem at all. For the record, Mr. Lassiter, would you please advise the court and the state of what the basis of your motion is?
Yes, Your Honor. Under the Barco-Wingo factors from the Supreme Court, a person is entitled under the Sixth Amendment to a right to a speedy trial. In this case, we filed a motion. I hope you have that in front of you with an order, Judge. Just basically outlining the facts of this case. Essentially, in, I guess it was February, or I think it's February 3rd of 2019, Ms. Stevens was in an accident. She was subsequently taken to the hospital where she was released. And she was never given any paperwork, never approached by an officer, never told she was being investigated, nothing, just absolutely nothing. And fast forward 1 year, 11 months, and 2 weeks, January 11th occurs, and the state, I guess, realizes that they didn't file a case. I don't know from what source it came from or anything, but they end up issuing a warrant for her arrest based on a warrant at large, which, as you well know, typically happens right after the fact if they're going to arrest for DWI. But the warrant was not issued until January 11th. Ms. Stevens is on the call as well. She's on the Zoom, Judge. Only found out about it when she was pulled over for a citation, and then the officer told her that she had a warrant. She immediately told me. I called everyone under the sun, Bexar County, Como County, Bexar County sheriffs. I couldn't find it. Nobody could find it. We actually had to go back and get the original warrant number from the officer, which was in June, I believe. And we finally got in touch with him. He gave me the warrant number, and that's the only reason we were able to find the case. I did speak with the state on this, and to the best of their knowledge, they do not know why there was a delay. The people that were involved are gone. And so based on the Wingo factors, I would submit to the court that a case has established presumptive prejudice after a year under the case law. And since there is presumptive prejudice and the state cannot rebut it, we believe that this is an appropriate case for a dismissal under speedy trial.
Let me back up a second, and then I'm going to want the state's response. The actual date of the accident was February, what, 2019?
I believe it was 3rd. Don't quote me on that, Judge. I don't even have discovery yet.
Judge, it was February 2nd, 2019.
February 2nd, 2019. Do you agree with that, Mr. Lassiter?
Yes.
Okay. And the actual information was not filed until January 14th, 2021. Is that accurate?
Roughly. I On my system, it says that it was filed January 8th, 2021, but at this point, Judge, doesn't really matter
Understand.
if it was the 14th or the 8th.
Okay, State, over to you. What's going on with this case?
Judge, I reached out to the intake prosecutors to see what could have happened, and the best response that I can give the court is that because that this case was filed at large, that it just got lost in the system. And I imagine whoever checks to see when our statute of limitations is going to run, that's when the state realized that the statute was going to run, and so it was filed at the very last minute. Judge, to be upfront, the state had the BAC since April of 2019, so I don't have a good reason for the court of why this case was never filed. Additionally, the only thing that we have going for us, Judge, which is not much, is that the defendant was read the DIC 24, so she knew she was under arrest at the time, but she was released to the hospital, and that's why it was filed at large, Judge.
In cause number 653674, State of Texas versus Alexis Stevens, defense motion to dismiss for lack of speedy trial is granted. Anything further from the state of the defense on Ms. Stevens?
No, Your Honor.
All right. Good luck, Mr. Lassiter. And
Judge, yes, and do I need to get with the coordinator about removing the warrant? The warrant's still active.
I'll take care of that. Pat, are you on with us this morning?
Yes, Your Honor, I'm here.
All right, we need to pull that warrant on Ms. Stevens.
As soon as the clerks get the order, Your Honor, they will do it.
All right. Thank you, Mr.
Thank you,
Lassiter.
Your
If
Honor.
we help you the other way, let us know.
Thank you.
All right. What's the status of our pleas from the jail guys?
Your Honor, we're missing the attorneys. And I know Joseph is coming for Miss Arizola for Judge Guerrero, but he is in the 199, the 399th, and then he has 14. He will come as soon as possible.
Okay, let's jump to our non-disclosure cases. Alexis, you had some information. I don't know you had a chance to share with Mr. Vale on his request for non-disclosure. Did you want to go in a breakout room and chat with him briefly and see if that saves us some time?
Yes, Judge.
All right, why don't y'all go chat because she thinks she's got some law to throw at you.
Okay, thank you, Judge.
Okay, Alexis, go in one. Vale, I will put you in one as well.
Thank you.
Hey, Pat, I have a question, please.
Huh?
Yesterday, I just received your email on Tuesday. Well, I looked at it after the game, so about midnight, I got your
Yes.
email for today's Zoom meeting.
Yes.
I just retained a lawyer yesterday, Stephen Gordon. So
Okay.
if possible,
You need to, wait, we need to talk to the judge. Judge, you
You're
want to,
talking to the judge. I'm happy as a lamb. I'm proud of you. I think everybody needs a lawyer, so it's not a problem whatsoever. If you would have, who is your lawyer at this time?
Stephen Gordon.
Would you just have Mr. Gordon contact Pat and we'll set up a new hearing date to give him time to go over this case with you and make his presentation. Fair enough?
Thank you, sir. Greatly
All right, you
appreciate
bet. Thanks, Mr. Berry. You're dismissed.
it. Thank you, Pat.
all righty, we'll get together. Okay, that's pretty good. All
This is
right.
going well.
Yeah. You can just get all the attorneys. Now, Mr. Goen, Mr. Danners, okay, and then Mr. O'Brien's, okay. Your Honor, Mr. Aliman supposedly thought it was at 8 o'clock this morning. He was at the courthouse and actually outside the courtroom. He was told it was at 10. He was kind of upset. So I don't know whether he's going to be coming in now or a little bit later or what, because he has not spoken to me.
Is there any reason for him to be upset because you told him it was 10 o'clock?
Well, he got it in his head that it was 8 o'clock, Your Honor. And so he was upset that he was there waiting when it was really.
Blame it on Mr. O'Donnell. I think that'd be a good plan.
Your Honor, it's always my fault.
Brian, I neglected to tell you yesterday, I found a little humor in the fact that Brian O'Donnell is representing whatever the other gentleman's client you had yesterday whose name was very Irish or Gaelic or something. I thought that was funny.
I'm on that wheel, Judge.
Let's see. We got Mr. Goins with us today. We do. Guillermo, can you go forward by yourself without having your trial partner with you on this case about an individual being charged with unlawfully carrying a handgun because he had marijuana in the car with the otherwise lawful handgun, and then y'all never filed charges on the marijuana?
Yes, Judge, I'll handle this one.
Okay with you, Mr. Goins?
That's fine, Your Honor.
All right, let's go into cause 650297, State of Texas versus Charles Danner. This is a motion to quash the information. Mr. Goins, would you please advise the court and the state what your basis of your motion is?
Your Honor, the basis of the motion is that there has been no charge of marijuana filed in this case. To prevail on a UCW, the state has to prove beyond a reasonable doubt that another violation occurred. And unless they file it as a marijuana case and get a conviction, they cannot even introduce the evidence because of the extraneous offense rule.
Okay, and did you send me a brief or some law on this? I believe at some point, I believe you sent me something, didn't you?
We did, Your Honor. We talked about it, and you talked about it with the state also at the same time and decided to have the hearing.
Okay, let me read your one sheet document here real quick.
I have a response, Judge, whenever the
I'm
court.
sorry, and Guillermo, go ahead and tell me what the state's position on this is, if you would.
Yes, Your Honor. So in this case, first of all, Judge, the state's position is that the motion to quash is not the appropriate remedy for what the defense is seeking, Judge. We believe that the defense has more than sufficient notice with the information that was filed by the state. So if anything, Judge, the remedy would be a trial or perhaps a motion to suppress, not a motion to quash. Now, Judge, in addition to that, so this case is charged as a, like Mr. Goins mentioned, as a underlying offense, UCW. So this is not a plain view, right? So in this case, Your Honor, there's no requirement that the state files or charges the defendant with a POM. And also, Judge, there's several ways that the state can prove this case. First, if it's not marijuana, then it's hemp. So we have sections 122.356 and 122.360 from the Texas Agricultural Code. And the name of this offense, Judge, is called the unlawful transportation of hemp. So if the defendant had a special permit to transport hemp, then that could be a defense, which I doubt that he has.
Okay, well, I assure you this is marijuana. If it's anything, it's not hemp. Go ahead.
Also, Judge, there's several ways that the state can also prove this case. And I don't want to get into the details of the work product, Judge, but just to be fair with the defense, we can prove this case with possession of drug paraphernalia under the Health and Safety Code. And also, Judge, we can prove this case under attempted possession of marijuana. So again, Judge, there's no requirement that the state proves that the substance was marijuana.
All right, let me back up a second. Is there an actual lab report on this amount of marijuana that was seized during this arrest?
Not in the discovery.
I don't think so, Your Honor.
And what was the exact amount of marijuana, alleged marijuana, seized during this arrest?
There's no amount alleged, Your Honor.
What's the law say? It has to be a usable quantity. Is that not what the basis of the law is these days?
Yes, Your Honor. And further, Your Honor, this goes back to the state has to plead with sufficiency in the information. You've already heard them change their story 4 times as to why this could be charged. They have to stay within the information, the underlying offense, and any elements of the offense that exist. They can't say he was in possession of a weapon, committing another offense and leave it at that, and then try to come back during a trial and say it could be one of 4 things.
I've never seen a misdemeanor information on unlawfully carrying a weapon, to wit, a handgun, in a vehicle that alleged that there was any other basis for the illegal. Normally it's a DWI with somebody carrying a handgun. And then the information for unlawfully carrying a weapon, I've never seen it ever alleged there's any other violation going on. I mean, obviously, we all know that one has to go on for the weapon to be illegal. Otherwise, it would be lawfully carrying a handgun. Do you agree with that?
Yes, Your Honor.
Well, I've never seen an information done that way, but maybe you're going to make a landmark case out of this. We'll see. All right. Here's did you find out there's a lab report on this marijuana? Guillermo?
Judge, I'm looking into the system right now.
No,
Your
there's
Honor.
not.
I probably not, Your Honor, because like I said, this case we can prove this case, several ways, Your Honor, but I mean, I can double check.
Okay.
But I don't think there's a
Here's
lot.
my question for both sides. And what I'm probably going to want to do is hear your final arguments on this issue. First, I want to make sure everybody agrees on the facts. The facts are that Mr. Danner was apparently pulled over for a valid reason, a speeding. I don't know what it was. Do you know what it was, Mr. Goins? Well, you're not objecting to the stop at this point.
I believe the reason for the stop was because he swerved on the road.
Okay. So let's say for the sake of conversation today in this hearing that the police had a valid right to pull him over. If and apparently he was not intoxicated because that was not filed against him, correct? There's no DWI or anything on him. And I don't know if the officer smelled marijuana or whatever, that gave him probable cause to search the car, or how they got to the marijuana. Do we know what happened on that?
I believe he did. I believe it was a smell test, Your Honor.
Okay. I've got a copy of the police report. Let me see what it says. Notice an odor of marijuana coming from the vehicle. Defendant stated he had a weapon in his waistband. Small amount, 3.9 grams that were in the back seat. And it's magnifying glass time for old eyes. Near subject 2. Does that sound parallel to the story of your defendant, Mr. Goins?
Yes, Your Honor.
Okay. And it's also my understanding, and state, correct me if I'm wrong, the state has a policy under the new DA, Joe Rodriguez, that y'all are not prosecuting small amounts of marijuana and other drugs. Is that accurate?
There are a few exceptions, Judge, but yes, that's accurate.
I mean, is that not your understanding of probably why this marijuana case was not filed in this particular matter?
That's correct, Your Honor.
Okay. So the state's trying to be nice, and Mr. Goins is going to stick you. I like it. It's all working for me. All right. Mr. Goins, is there anything to add to this? Because I think I've got the facts down. I just need to run it by my staff attorney, Ms. Bauman, and do a little research on my own, and then I'll get back to you guys with a ruling on it. I don't want to make a mistake.
Your Honor, the main thing is they have to prove beyond a reasonable doubt another offense, whether it's marijuana or anything else.
What the state is telling, do you have more to say? I'm sorry, go ahead. Cut you off. All
Your
right.
Honor?
What the state is saying, best I can tell, is they don't need to actually file a information and prosecute for possession of the marijuana because that's not their policy, and that's above Mr. Flores' head in the department. However, all they have to do is put an officer on the stand to say that he found marijuana. And then the jury can either believe him or not, but that's another offense, and the jury can believe that or not. So it's all
And,
jury
Your Honor,
questions.
and my argument is that's an extraneous offense that can't come in during trial.
Your Honor, the state will counter again, Judge. There's several ways to prove this case beyond reasonable doubt, and but there's no requirement, as far as I know, that we have to file the POM.
Okay, Mr. Flores, what is your response to Mr. Goins' allegation that you can't bring up a separate offense during the trial of this offense?
Well, Judge, the information says, and it's based on the statute, of course, this is a UCW based on the fact that the defendant was engaged in criminal activity other than a Class C misdemeanor that is a violation of law or ordinance regulating traffic. So, of course, Judge, the section that I just cited on the Texas Agricultural Code, basically that section, which is the unlawful transportation of hemp, that's obviously not related to traffic, Judge. Also, the possession of drug paraphernalia, that's also not related to traffic.
All right, let me stop you there. And I don't know what kind of container this marijuana was in, but what do you call drug paraphernalia? Is there a pipe or anything in this car?
Oh, Judge,
I mean, there's marijuana, but marijuana is not drug paraphernalia, I don't think. I think it's marijuana.
right. I'm looking at the police report right now,
Right.
Your Honor.
Mr. Goins, do you know of any, quote, drug paraphernalia, unquote, involved in this arrest?
No, Your Honor, I don't. And even if there were other paraphernalia, any of that evidence would be an extraneous offense, which cannot be brought up during trial.
Okay. Ms. O'Connor, you were actually the original attorney on this case on the state side. Do you have anything to add?
Sorry, Judge, I came in halfway through this argument.
Okay. Well, I'll go down to, go ahead.
Isn't the state obligated to prove the criminal activity part since we're alleging it in the information?
Well, I'm gonna run that all by my staff attorney because this question hasn't come up before. But as everybody's aware, we get lots and lots of DWI charges. And then we also get an allied unlawfully carrying a weapon handgun charge based explicitly on the fact they had a DWI at the same time they're carrying the handgun. Otherwise, it would have been squeaky clean legal for the person to have the handgun in his vehicle on or about his person. So on any of those informations or all those informations, it's never alleged as unlawfully carrying a handgun because he was also charged with a DWI. It just says unlawfully carrying a handgun. So Mr. Goins, I'll have Brooke research that issue and see if you're right that they have to allege why it's unlawful, i.e. that the person got a DWI or a possession of marijuana at the same time he had the handgun. And B, I'll see what Brooke says about whether or not the state is required to charge this particular possession of marijuana in order to get a conviction for the unlawfully carrying a handgun. I don't think in the statute anywhere it says that the state has to actually charge a second offense. It just says he has to commit a second offense, which in my mind is a jury question. And they've got to prove it to a jury. But let me run it all by Brooke and I'll get back to you guys with an answer. Would that be fair?
Yes, Your Honor. And again,
if there's anything else anybody wants to send me, I do have kind of a casual brief from Mr. Goins on it, but state, I don't know that I have anything in writing from you. I do have a police report, so I know what happened on the police side at least. But let me get Brooke to research that and I'll get back to you guys probably next week. Fair enough?
sounds good,
Judge,
Your Honor.
Yes, sir.
real quick, Judge. I think currently we're set for Tuesday. Do you want to do it on Tuesday or do it later?
Do what? Have another hearing?
We have a hearing set already in this case for Tuesday.
Oh, okay. No, we're going to waive that one. All I need to do now is make a decision. I need you to get the facts out from both of you guys. And I think we're all on the same sheet of music with regard to the facts. Now I have to determine what the law is to apply to the facts. That's where we're at.
And just to emphasize again, Judge.
I've got everything I need to know except research from my staff attorney.
And also, Judge, we believe that this is not the proper remedy to quash the information. We believe that goes to the merits of the case. But yes, Judge, we'll wait for the court's decision.
Okay. All
Your
right.
Honor, I will take him off of the arraignment docket and I will reset it, give it time.
Yeah, I think that was to keep you on my radar so I didn't lose you in the shuffle.
I understand, Your Honor.
All right. Thanks, Mr. Goins.
Thank you. May I be excused?
You bet. Okay. What did Ms. O'Connor, what did you and Mr. Vale come up with?
Judge, defense counsel was unaware of the criminal history outside of Texas for this defendant. So I need, at the bare minimum, proof that certain charges that he's been charged with in California, I need the disposition data of that. I need to know if they were dropped, if he was acquitted, guilty. I don't have anything.
Is Mr. Vale still here on the Zoom today?
Your Honor, Mr. Vale and his defendant are in a breakout room right now.
Oh, okay. Didn't you uncover some statute or something that says that this person had to be on deferred adjudication probation in order to be eligible for a non-disclosure order?
Yes, Judge. And he informed me that it was amended, but I told him to send me what he's looking at because what I'm looking at is not what he's looking at. So, especially because the offense happened so long ago, I feel like we're looking at two different versions of the code. So I asked him to send that to me.
What does the D page say it was?
Your Honor, it was initially a regular probation.
Okay. And
He was never given a deferred and then it amended, Your Honor.
Right. Defense counsel told me that the legislature has amended it to where DWI first on regular probation can also qualify. But in my research, that's not what I found, Judge. So I just asked him to send me what he has so we can look at the same thing.
Okay. Well, I'm looking now at the document you sent me, which is Orders of Non-Disclosure Overview from the Office of Court Administration.
Right.
And it very clearly and unequivocally says the person must have initially been placed on deferred adjudication community supervision.
Correct.
So isn't that just a black and white? He can't get a order of non-disclosure if it wasn't deferred adjudication?
That's my understanding, Judge. But what defense counsel is saying is that that's old law, but I haven't seen the law that he's looking at.
Okay.
Maybe defense counsel can
Let's
send that.
let them come back and tell us what they want to tell us, and then we'll either reset it or go from there. So let's hold short on that one. Mr. Aleman, we had you today for a plea on Mr. Chavez.
It's an MTR, Your Honor. It's an
What's going on?
MTR, and she has signed the paperwork, so you need to sign it.
Judge, but I need to speak to the prosecutor first, because I don't
problem.
understand what they want to do,
Okay.
because I couldn't read.
You want
And
the
we
mean
need
prosecutor?
Susan.
That would
Oh,
be Ms.
Suzanne's.
O'Connor. Do you want the
Excuse me.
nice prosecutor would be Mr. Flores? Which one do you want?
Well, Mr. Flores is the one who sent me the information, so I
right.
guess I should probably speak to him.
Will you send Mr. Aleman and Mr. Flores into a chat room too?
Yes, of course.
In the meantime, I'll sign the document.
Also, Judge, just so you know, I'm going to handle the hearing with Mr. O'Donnell.
O'Donnell?
So, yes, so just other than
No
that,
problem.
all right,
We'll wait for you. You're not going anywhere.
sounds good.
Okay, Mr. Aliman, you can go back to room 2, and Mr. Flores should be there in a little bit.
Okay. Can you give me something to get on, because I can't see. Can't see very
Okay.
well, and if you give me a.
Okay, let me do this. Hold on. Let me move you to 3, and that way you can see the little sign.
There it is. Okay, I see it. Thank you.
All right, Your Honor, you have both paperworks for the MTRs, and you need to sign them.
Roger. Both signed.
Thank you, Your Honor. I'll send them to you as soon as they come to my email address. Okay, so it's going to be reset. I'm waiting to see on that one.
Okay, Alexis and Brian, do y'all want to go forward on these motions or motion to dismiss for lack of speedy trial while we're waiting? I don't know how long Mr. Bale is going to be.
Joseph, I'm going to put you and Miss Arizola in a breakout room so you can talk.
Yes. Thank you, Pat.
You're welcome.
Let's start with cause 633-445, State of Texas versus Patrick Alonzo Salazar. Is this person currently in jail? Hopefully not.
No,
Oh, Your Honor.
Mr. O'Donnell, would you go ahead and state for the record and the court and the state what your basis of your motion to dismiss for lack of speedy trial on Mr. Patrick Alonzo Salazar, case 633-445 is?
Yes, Your Honor. Thank you. The date of offense for this case is February 12th, 2020. As far as I know, as of this morning, there was still no complete file from e-discovery. We filed our motion for speedy trial April 9th, 2021. And we filed our motion to dismiss June 1st, 2021. I have been in contact with my client, and he is very anxious. He's been on pretrial this entire time. He's deemed indigent, and we're relying mostly on Harris versus State, wherein a delay of more than 8 months has been considered to be presumptively unreasonable. If that's so, that would trigger the Barker versus Wingo analysis, wherein the question for the court would be whether the delay is uncommonly long. And from my client's point of view, although he is out of jail on bond, it is very difficult for him. He's been identified as having special needs, including mental health issues, Judge. It's not my client's fault. He can't produce the lab test result. Only the state can. He is asserting his right to a speedy trial, and we believe that this has resulted in prejudice to him. And my client was informed about today's hearing. I talked to him, and he says he did not want to appear. He has severe anxiety, Judge. Nothing further, Judge.
Okay, let me get the dates on the table in front of me, and then I want to hear the state response. Okay, I've got the offense date, and I guess he was arrested for DWI first. That sound right?
Yes,
On
sir.
February 12th, 2020. Is that correct? Brian, is that correct? February
That is
12th,
my
2020 is the
understanding.
arrest date. And then
Yes,
has the information been filed yet?
I don't believe so, Judge.
Date, has the information been filed on this case?
Judge, the information has been generated and sent to be rush filed, but at this moment, it has not been filed.
Okay, I guess that's all I need to know for now. State, what's your response, please?
Judge, it's the state's position that we obviously know a 17-month delay is presumptively unreasonable. However, the reason for delay is the defendant was arrested February of 2020. Everything shut down March of 2020. And by shut down, Judge, not only were the courts shut down, half the world was shut down. The state did not have possession of the lab results until July 13th, 2021, last week, Judge. And once we received the lab results, we rush filed the case this week, Judge. It's our position. I understand the defense is saying that the burden should shift to us because the length of delay is so excessive. However, it's the state's position that because we were in the middle of a pandemic, that it does not relieve the defendant of their burden to show that their defense has been prejudiced and impaired, and they haven't put on evidence that the defense was in any way impaired, Judge. The only thing that we've been waiting for was the BAC results, and that was either going to come out two ways, either under 0.08 or over 0.08. Everything else has been in the file up until now. The witnesses that were listed in the police report, the numbers were in there, their date of birth was in there. The defendant could have reached out to them at any time. I don't understand how the defense would be prejudiced, considering the police report would never disappear, officer's testimony would never disappear, the blood results would never disappear once we got them. And defense counsel did mention that the defendant had anxiety, but the CCA has already said that generalized anxiety, although it's relevant, is not sufficient to prove that they've been overly prejudiced, Judge. And I don't see anything in the motion other than a mention of generalized anxiety. And additionally, the defendant was booked and released on a PR bond the same day, Judge. He's not been in jail. He's been out. He's been living his life. The only thing that's really held up this case is a global pandemic, Judge.
Mr. Donahue, I'm sorry, Mr. O'Donnell, the prejudice to the defense. I know you talked about anxiety. Is there any other prejudice that the defense incurred as a result of this delay?
Well, I asked my client, Judge, whether he lost a job because of this. He said no. He is actually on a fixed income. He's on a disability income, but he did stress that he feels like he's already on probation. The standards to stay on pretrial are pretty strict, and the feeling of unknown. The state, there's been a worldwide pandemic. There's no doubt, Judge. At the same time, the state could dismiss the case and refile. My client has special needs. The county recognizes that. I'm so glad that he has been complying, or else he would be in jail waiting for a lab test. My client chose not to come on and testify, but this is what he would have said, Judge. Nothing further.
My understanding is that there's a statute limitation on the state actually filing an information on a misdemeanor case of 24 months. Does that sound right?
Correct, Judge.
Yes.
You got to file it within 24 months, and they've done that. Or actually, you haven't even filed the information as of today. Is that correct? But it's in the process of being filed. It just has not been filed.
Correct, Judge. It's our office policy that we can't file the case without a number, and we received the number last week.
What's the number for the sake of conversation? To see if this is marginal or not. What's your number?
1 second, Judge. Let me pull it up. The number is
The alleged number. Yeah.
0.216.
Okay, well, that's colorful. Okay, I'm looking at the Barker-Wingo factors. Length of delay, we got that one. Reasons for delay, we've got the famous DA COVID defense. Assertion of the right to speedy trial, no problem with that. Prejudice to the defendant is the one I'm hung up on. I just don't see any real prejudice to the defendant. Everybody gets anxiety when they're charged with a crime, and I understand that. But that's my problem. That's my hurdle, Brian. I'm not getting the prejudice for the defendant.
I understand, Judge. I don't have any additional testimony. My client chose not to appear.
And
This is the first I've heard of the blood alcohol content, Judge.
well, see, when you file these things, it does good things because it puts a bird under the state saddle to jump on these cases and get them moving. So at least you got that going. All right, this is we're talking on Mr. Salazar's case, right? 633-445.
Yes, Your Honor.
Okay. And cause 633-445, State of Texas versus Patrick Alonzo Salazar, defense motion to dismiss for lack of due diligence and violation of right to speedy trial is respectfully denied. Anything further from the state of the defense on Mr. Salazar?
Nothing further, Judge.
Okay, got to take that one. Now let's go into, we got Mr. Vale back. Mr. Vale?
Hey, Judge, I need to visit with Alexis just for a few more minutes if I could.
Sure. Is that okay, Alexis?
Yes, sir.
Yeah, and then
Mr. Vale, do you remember what room you were in?
I was in breakout room 1.
Okay, Alexis, let's see if we can get you back into 1. You're gonna try, you should be there. You both should be able to get back. Okay.
okay, Guillermo, let's do the speedy trial, motion to dismiss for lack of speedy trial on Mr. Michael Reff III, which is cause 642-487. Also represented by Mr. Brian O'Donnell. Mr. O'Donnell, on this case, would you please advise the court and the state what the basis of your motion is?
Thank you, Your Honor. The date of offense is July 4th, 2020. We filed our motion for speedy trial March 30th, 2021. My understanding is that motion was granted on April 19th, 2021. We filed our motion to dismiss for due diligence on speedy trial May 7, 2021. Case was set for hearing, and I discovered on July 20th, just 3 days ago, now there is a file, and the lab test in e-discovery is dated October 29, 2020. So although we have a file now, the state put the lab test results, I guess, after we filed for these motions. Judge, I still think that that is a presumptively prejudicial delay. And under Harris versus State, this was a delay for more than 8 months. We would ask that the court dismiss the case for lack of speedy trial.
Okay, and what prejudice is involved in this case?
Your Honor, my client, I have not been in contact with this client. The police report indicates that on the date of the arrest, my client was taken to a mental health facility. And
Judge, and I'm going to object on hearsay, Your Honor. I believe that the Texas rules of evidence apply in this type of hearing.
And I'm sorry, what is your objection?
Hearsay, Judge.
I'm sorry, say again?
Hearsay.
Hearsay. I'm going to overrule your objection for purposes of this hearing.
Yes.
Let's get all the cards on the table. Okay, Brian, he was arrested, and I'm sorry, I don't even know what he was
Yes.
arrested for. The DWI or something else?
this is a possession of a controlled substance case.
Okay.
And I'm just reading from the police
I
report.
understand, but a misdemeanor controlled substance, not a felony controlled substance, right?
That's correct, Judge.
I mean, otherwise it wouldn't be in this court theoretically. Okay, so he was taken to a mental health facility. What mental health facility was he taken to?
Yeah, let's see. It is Methodist Specialty Transplant off of Floyd Curl.
And why did they do that? Do we know?
It's I think because of the drugs that he had. He said that he had prescriptions, but he didn't have them with him. He could not produce it. And then it just says they identified the pills through drugs.com. And he was informed that he would be taken into custody on this charge and transported under their protocol to that facility to have a SANE exam completed. It was completed and he was processed and released.
So was he ever put in jail?
I don't believe so, Judge. He's been out on bond and hasn't responded to we haven't had a court date. But I have had no contact with him, Judge.
Okay. And as far as prejudice goes, I haven't heard about any prejudice yet, other than the anxiety everybody would get. I understand.
It would be, I don't have evidence to produce on that, Judge. I have had no contact with him. I'm relying on the time period
So
alone.
as we speak right now, can you call him on the phone or find him in any way?
No, Judge, I've been trying the last few days to get some. I do have a phone number, but it says that the mailbox is not set up yet.
Okay. Anything further, State? I think I got it.
No, I agree with the prejudice factor under Barker, Judge. So that's all we have.
Anything further, defense?
No, Your Honor.
Motion to dismiss for lack of speedy trial on Mr. Michael Reff III, cause number 642-487 is respectfully denied. So right now, as we speak, is there an information file on this case?
I believe there is.
Yes, Your Honor. And,
Okay, well then we're good on that. Brian, you want more time to try to find this guy, or you want me to issue an FTA warrant on him? We can't let him just be out running around without at least being in contact.
Your Honor, I think currently the case is set for September 14. If we could have maybe a 2-week reset, or I can send at least another letter because I am concerned about him, Judge. I don't want a warrant to go out.
I'm gonna give you one more week to find him or make contact with him. And you can, any way you want to do that. He's on bond, is he not? With somebody?
Yes,
PR
yes.
probably, or what?
Yes. Yeah.
They can't find him either?
Well, I don't have that information, Judge. But
Pat, just remind me next Friday, or write this down, just to get back with Mr. O'Donnell and see if he's found this gentleman or not. And if you do find him, let Pat know before next Friday and we're good.
Very well. Thank you very
Thank
much.
you, Brian. You're dismissed.
Thank you, Judge.
Okay, what else we got? Let's see.
You have the MTRs, Your Honor, and Joseph Stateson is there for Monica Guerrero, and he is talking with her now in a breakout room. I believe Mr. Aliman has already talked to
Flawless.
the paperwork, sir, has already been emailed to you for both cases.
Okay.
Just get them print.
Whatever reason I didn't know these were MPRs. I'm sure I check marked the wrong paragraph. And I probably thought they were pleased. Let me see what I did. Hang on.
I just need to speak to this Aleman. I just need to speak to my client for about 15 seconds to tell her what's going to happen. I've
You
already explained most of it.
Have time.
You bet, no problem.
I took her for 15 seconds.
Okay, Mr. Aleman, I'm gonna put you in another room, okay?
Okay. I'll be right back.
All right, hold on. Let me find you and get you in there. Okay, Mr. Aleman. Move to
Here we go.
Sydney. Okay,
Judge, if you're looking for hard copies on court summaries, they'll be in yesterday's stack.
I think I still got them from yesterday.
Well, that's where they should be.
Yeah, they gotta run to the restroom.
oh,